Hello everybody, welcome to iExamB's Legal Week. This is Amrita, your law faculty here at iExamB. Embrace the iExamB learning experience with us on our exclusive law channel that is Legal Week. लीगल पी पे आपको सारे ही लॉ से रिलेटेड वीडियोस मिल जाते हैं जो लॉ एग्जामिनेशन से रिलेटेड होते हैं. These videos help you out in preparing for various examinations starting from SEBI, RBI and whatnot. जो भी एग्जाम्स में लॉ ऑफिसर की पोस्ट आती हैं, we try to cover them by way of online courses that are available on our website. You can check out the demo of all the courses on www.iexamb.com. You can also call us on 9205524028 and if you have any queries, you can get it resolved. आप हमें ईमेल के द्वारा भी कांटेक्ट कर सकते हैं by writing us an email on hello@iexamb.com. इस वीडियो के कमेंट सेक्शन में भी अगर आप रीच आउट करते हैं, we will try to contact you as soon as possible. So don't forget to subscribe to Legal Week for that purpose. Prepare 50% faster with us at iExamB. मैंने रिसेंटली एक वीडियो सीरीज स्टार्ट की है स्पेशली फॉर सेबी ग्रेड ए लीगल ऑफिसर एग्जामिनेशन दैट इज बेस्ड ऑन द प्रीवियस ईयर पेपर. प्रीवियस ईयर पेपर मैंने पिक किया है 2023 का. फेज 1 से रिलेटेड मैंने 2 वीडियोस बनाई थी, पार्ट 1 एंड पार्ट 2, जिसमें मैंने आपसे 50 MCQs डिस्कस किए थे दैट केम इन द प्रीवियस ईयर पेपर ऑफ सेबी इन 2023 जो कि फेज 1 से रिलेटेड था. इस वीडियो में मैं फेज 2 का डिस्कशन स्टार्ट करने वाली हूँ. फेज 2 पेपर 2 दैट इज द लॉ पेपर. So we will be discussing the MCQs for the first part in this video. I will be covering this also in parts only, similarly like I did for the first phase. So let us start with the first question. Yes, one more announcement before we start with the discussion. As you can see that there have been many selections from iExamB, the students who have enrolled to our courses, interview courses as well, and they have joined SEBI as law officers. And also these are the details of our online course. We give you live sessions, notes, descriptive questions, MCQ booklets, interview guidance, practice tests and everything here at iExamB online course. उसके details आप इस number पे call करके check out कर सकते हैं. So the first question is, this is of phase 2. As per section 25 of Companies Act, what constitutes evidence that an allotment of securities was made with a view to the securities being offered for sale to the public? If an offer is made within 3 months after the allotment or agreement to allot, if an offer is made within 6 months after allotment or agreement to allot, if the whole consideration is received by the company before the offer is made, both A and C are correct, both B and C are correct. सो ये यहाँ पे उन्होंने डायरेक्टली आपको सेक्शन नंबर भी दिया हुआ है. कंपनीज एक्ट है, काफ़ी वेटेज भी था इसका फेज 2 में भी. सो यू विल बी एबल टू अंडरस्टैंड द इम्पोर्टेंस ऑफ दिस सब्जेक्ट बाय गोइंग थ्रू ऑल दीज क्वेश्चंस. सो द करेक्ट आंसर ओवर हियर इज बी. इफ एन ऑफर इज मेड विद इन 6 months आफ्टर द अलॉटमेंट और अग्रीमेंट टू अलॉट. डायरेक्ट सेक्शन बेस्ड क्वेश्चन है ये एंड आंसर भी काफ़ी डायरेक्ट है. विच ऑफ द फॉलोइंग इज ट्रू रिलेटिंग टू शेल्फ प्रोस्पेक्टस? Filed with the registrar at the stage of the first offer of securities, it is valid for a period of 1 year from the date of opening of the first offer of securities under that prospectus. An information memorandum it is, containing all the material facts relating to the new charges created, changes in the financial position of the company as have occurred between the first offer and the succeeding offer of securities that is required to be filled by the company. All A, B and C, both B and C. So all the types of prospectus are an important concept in Companies Act that you have to go through. यहाँ पे इस क्वेश्चन में शेल्फ प्रोस्पेक्टस के बारे में पूछा गया है. करेक्ट आंसर इज डी, ऑल A, B and C. All the conditions that have been provided are covered under shelf prospectus only. Section 31 covers the concept. This PPT also you can download with yourself. Due to paucity of time, I am trying to be bit quick in the video. बट आप इस वीडियो में से पॉज करके भी क्वेश्चंस को आराम से, एक्सप्लेनेशंस को आराम से रीड कर सकते हैं, या फिर आप इस पीपीटी को डाउनलोड करके रख सकते हैं. इट कैन बी अ रेडी रेफरेंस फॉर यू टू हैव दीज क्वेश्चंस. अकॉर्डिंग टू प्रोविजंस ऑफ द कंपनीज एक्ट, द अमाउंट ऑफ द डिविडेंड इंक्लूडिंग इंटरिम डिविडेंड शैल बी डिपॉजिटेड इन अ शेड्यूल्ड बैंक इन अ सेपरेट अकाउंट विद इन डैश 5 days from the date of declaration of such dividend, 7 days from the date of declaration of such dividend, 30 days from the date of declaration of such dividend, 90 days from the date of declaration, such period as the central government may specifically provide for. Correct answer is A, 5 days from the date of declaration of the dividend as per section 123, which directly covers with the concept of declaration of dividend. उसमें clause 4 अगर आप देखेंगे तो उसमें specifically यहाँ पे mention किया हुआ है within 5 days from the date of declaration of such dividend. Every company shall at the first annual general meeting appoint an individual or a firm as an auditor who shall hold office from the conclusion of that meeting till conclusion of its 6th annual general meeting, hold office from the conclusion of that meeting till the conclusion of its 6th annual general meeting, and thereafter till the conclusion of every 5th meeting. Hold office, same thing is there, they are just changing the second part, and thereafter till the conclusion of every 6th meeting, till the conclusion of meeting, none of the above. So some or the other words have been changed. If you are clear with the concept, you can solve it. C is the correct answer. Hold office from the conclusion of that meeting till the conclusion of its 6th annual general meeting, and thereafter till the conclusion of every 6th meeting. Covered under section 139 that talks about appointment of auditors. As per the provisions of Companies Act, the IEPF shall be credited with dash. Donations by state governments for the purposes of the fund, amount given by central government by way of donations after due appropriation made by the Parliament by law, amount in the unpaid dividend account of companies transferred to the fund, all A, B and C, both A and C. So the correct answer over here is E only, that is both A and C. Donations by the state government for purpose of the fund, amount in the unpaid dividend account of companies transferred to the fund. It is covered under section 125, Investor Education and Protection Fund. This is the full form of IEPF, which is covering in detail everything what is going to be credited. As you can see this entire section and go through it in detail. इस तरीके के फंड से related भी questions अगर पूछे जाते हैं, so you have to be clear with that. According to Companies Act provisions, dash means such capital as is authorized by the memorandum of a company to be the maximum amount of share capital of the company, nominal, paid up, called up, subscribed, reserved. So what means such capital as is authorized by the memorandum of the company to be the maximum amount of share capital to the company? According to Companies Act, answer is A, nominal. Section 2 clause 8 of Companies Act deals with authorized capital, which is also known as nominal capital. So this is what is talking about nominal capital. Where a company is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction, such a company or an inactive company may make an application for obtaining status of dormant company, make an application to registrar for obtaining status of a dormant company, make an application to registrar for obtaining the status of an inoperational company, make application to central government for obtaining status of a dormant company, make an application to the tribunal for obtaining the status of a dormant company. So the correct answer is B, may make an application to registrar and obtain the status of a dormant company. Dormant company का description section 455 में अच्छे से दिया हुआ है, so that you can go through. आप इन sections को भी note down करके रख सकते हैं. You can find these as important sections for your future reference. According to section 96 of Companies Act, the annual general meeting of an unlisted company may be held at any place in India if consent is given in writing by all the members, consent is given by electronic mode by all the members in advance, consent given in writing by or by electronic mode by all members in advance, consent is given in writing or by electronic mode by all members in advance and approved by the board, consent is given in writing or by electronic mode by all the members in advance. So section 96 you will have to refer for this. Correct answer is C, consent given in writing or by electronic mode by all the members in advance. Where a resolution is passed at an adjourned meeting of a company, the resolution shall for all purposes be treated as having been passed on an earlier date, having been passed on the date on which it was in fact passed, having been passed on the date on which it was in fact passed, and shall not be deemed to have been passed on any earlier date, having been passed on the date on which it was in fact not passed, and shall be deemed to have been passed on any earlier date, none of the above. See, you have to be very careful with such kind of questions where only some or the other words are changed, especially when such kind of things happen. And if we are in a hurry when we are solving the MCQs and exam, then we make silly mistakes. So इस तरीके से चीज़ें नहीं होनी चाहिए. Be very careful, vigilant, relaxed when the questions come in front of you. Correct answer is C. Having been passed on the date on which it was in fact passed and shall not be deemed to have been passed on any earlier date. Section 116 talks about it. No company limited by shares shall, after the commencement of Companies Act 2013, issue any preference shares which are cumulative, convertible, irredeemable, redeemable, non-convertible. So the correct answer over here is irredeemable. Companies Act Section 55, issue and redemption of preference shares. So no company limited by shares shall, after commencement of this act, issue any preference shares which are irredeemable. That is correctly and direct question that is asked from this section. As per provisions of LLP Act, how can a firm convert into an LLP? In accordance with provisions of Chapter 10, Second Schedule of LLP Act, Chapter 10, Third Schedule of LLP Act, Chapter 9, Second Schedule of LLP Act, Chapter 12 and 5th Schedule of LLP Act, and or Chapter 10 of the LLP Act. So which is the most appropriate answer over here? Direct question hai ye, knowledge based. Answer is A. That is Chapter 10 and Second Schedule of the LLP Act. Section 55 talks about it. According to LLP Act, a person may apply to the registrar for the reservation of a name set out in the application as the name of a proposed limited liability partnership, name to which a limited liability partnership proposes to change its name to which an LLP might change its name, either A or B, either A or C. Correct answer is D, either A or B. Section 16 of the Act talks about it. That is A or B, name of a proposed LLP or the name to which an LLP proposes to change its name. As per LLP Act, where the tribunal makes an order under Section 60 sanctioning a compromise or an arrangement in respect of an LLP, it shall have power to supervise the carrying out of the compromise or an arrangement, shall delegate the power to supervise the carrying out of compromise or an arrangement, may at the time of making such order or at any time thereafter give such directions in regard to any matter or make such modifications in the compromise or arrangement as it may consider necessary for the proper working of the compromise or arrangement. Both B and C, both A and C. So they have given you the section number also over here. According to that, you have to answer. Correct answer is E, both A and C. Section 61, power of tribunal. In that they have mentioned this section as well. This also we have to be very careful. Section 61, power of tribunal to enforce compromise or arrangement. In that, where the tribunal makes an order as per under Section 60. So this you have to be careful that which section is also mentioning any other section and that statement is picked up and all. Under LLP Act, Section 63 lays down that the winding up of an LLP may be voluntary, may be by the tribunal, may be either voluntary or by tribunal, and LLP so wound up may be dissolved, may be either voluntary or by registrar of companies and limited liability partnership, so wound up may be dissolved by an order of the tribunal, none of the above. So winding up of LLP may be either voluntary or by the tribunal, and LLP so wound up may be dissolved. So the correct answer is C. Section 63 deals with winding up and dissolution. According to IBC, if the operational creditor does not receive payment from the corporate debtor or notice of the dispute, the operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process. So what is the period for delivery of the notice or invoice demanding payment? 10 days, 7 days, 15 days, 14 days, 45 days. Question looks very lengthy, but it is simple, and the question is actually having a very direct answer. If you know the number of days, then you can very easily within seconds answer the question. Correct answer is A, 10 days. Section 9 of IBC deals with this. This topic is very important, so you have to be very clear with the questions in and out. As per IBC, the adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be NL National Law Tribunal having territorial jurisdiction over a place where the registered office of the corporate person is located. National Company Law Tribunal having territorial jurisdiction over the place where the registered office of the corporate person is located. NCLAT. Now you see the difference in the options. Appellate Tribunal ऐड कर दिया है यहाँ पे. So इस तरीके से थोड़ा थोड़ा चेंजेस करके ऑप्शंस बनाए जाते हैं. यहाँ पे कंपनी लॉ ट्रिब्यूनल ऐड कर दिया है, यहाँ पे IBC ऐड कर दिया है, IBC बोर्ड. So the correct answer is B, National Company Law Tribunal. Section 60A of IBC is dealing with this concept. What is the default amount for initiating the CIRP as provided under the IBC? 1 lakh, 10 lakhs, 1 crore, 10 crores, such amount as may be prescribed by the central government. What is the default amount for initiating CIRP has been asked over here. Correct answer is C, 1 crore. Section 4 of IBC deals with the application of this part. That is covering that. The entire process of corporate insolvency resolution process can be initiated by dash under IBC. Corporate debtor, financial creditor, operational debtor, all A, B and C, both A and B. Correct answer is E. Section 6 of IBC deals with persons who may initiate corporate insolvency resolution process. All these people can initiate. So the correct answer will be A and B, corporate debtor and financial creditor. Dash as per IBC means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Operational creditor, operative creditor, financial creditor, corporate creditor, either A or B or D. Now you can see what they have added, or. So or means only one is correct. This can be correct at a time. That can be correct at a time. Not all can be correct. So और word भी यूज़ किया तो वो भी आपको ध्यान में रखना है. बट ऐसे ऑप्शन से कंफ्यूज नहीं होना है. करेक्ट आंसर इज ऑपरेशनल क्रेडिटर. सेक्शन 5 definitions. You can see the clause 20. Operational creditor is a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Which chapter of IBC deals with the provisions relating to fast track insolvency resolution process? This is an important question. I would say chapter number पूछा गया है, ठीक है. You can not focus more on that, but focus that this topic is important. You go through all the important concepts. ऐसा नहीं है कि जो question पूछा है वही पूछा जाएगा next time. But उसके वजह से आपको ये तो पता चल जाता है कि कौन से topics important है और इन topics से questions आ सकते हैं. Correct answer is A. Chapter 4 deals with this. For fast track corporate insolvency resolution process. Section 55 to 58. Corporate debtors shall be resolved under IBC as per Section 54 by the order of Appellate Tribunal, Adjudicating Authority, National Company Tribunal, Registrar of Companies, Insolvency and Bankruptcy Board of India. The correct answer is B. Adjudicating Authority. Section 54 of IBC deals with dissolution of corporate debtor. Provisions as laid down under IPC provides that nothing is an offence which is done by a child under 7 years of age is represented by which doctrine. ये provision तो आपको पता ही है, doctrine भी बहुत famous है. I think the answer is very easy. Correct answer is Doli Incapax. Legal maxim है ये, एक Latin. Incapable of doing any harm or incapable of committing a crime, ये उसका meaning है. And ये child below 7 years के लिए applicable होता है. Section 82 of IPC deals with it. According to Indian Evidence Act, what is the number of witnesses that are required for proof of any fact? At least 2 witnesses, 3 witnesses. No particular number of witnesses are required. Such number as the parties may decide. Such number of witnesses as the court may order. Correct answer is C. No particular number of witnesses are required. Section 134 talks about the number of witnesses in Indian Evidence Act. According to Indian Evidence Act, when the question is whether a man is alive or dead, and it has been proved that he has not been heard of for dash by those who would naturally have heard of him if he had been alive, burden of proving that he is alive is shifted to the person who affirms it. ये डायरेक्ट क्वेश्चन है, सिर्फ आपको फिल इन द ब्लैंक करके ईयर पूछा गया है, एंड ये भी काफ़ी इंपॉर्टेंट क्वेश्चन है. Correct answer is A, 7 years. Section 108 talks about it in Evidence Act. Burden of proof is a very, very important topic from Indian Evidence Act. Especially this year's question is very, very commonly asked. Which of the following are the exception to Section 499 of IPC, which lays down provisions relating to defamation? Imputation in the form of an alternative or expressed ironically. Impute anything which is true concerning a person. It is for public good that the imputation should be made or published. Express in good faith any opinion whatsoever respecting the conduct of a public servant in the discharge of his public functions or respecting his character, so far as his character appears in that conduct and no further. All A, B and C, both B and C. Correct answer over here is E, both B and C. That is imputing anything which is true about any person for public good. It can be published or made. Yeah, and along with that another imputation, that is expressing a good faith in any opinion that is being reflected about a public servant. So ये दोनों भी points covered है section 499 defamation के exceptions में. I have picked up those exceptions here. The first exception talks about the imputation of truth for public good, and the second exception is public conduct of public servants. So this is how there are many exceptions in this, but here I have picked only the relevant ones to this question and this explanation. So this was the first part of my video for the phase 2 of previous year paper 2023 law paper MCQs. I'm going to cover all the 70 MCQs. This was the first part in which I have covered the first 25 MCQs of the same. I hope this is helping you all out. कोई भी queries हो सीधे reach out कीजिए हमें by any of the modes that I mentioned over here. Don't forget to subscribe to Legal B and prepare 50% faster with us at iExamB.